Good afternoon, everyone. Most of you in this room know this already, but my name's McKercher. I'm a professor here at the Law College, and I'm wearing two hats right now. One is the coordinator of the Dispute Resolution Program, which is what has caused most of you to gravitate towards this room. But I'm also the chair of the McKercher Lecture Series this term. And this event is also the kickoff event for the McKercher Lecture Series this term. As we gather for our speakers' events, it's our custom to acknowledge that we're on Treaty 6 territory and the homeland of the Métis. And so we pay our respect for our First Nation and Métis ancestors of this place and reaffirm our relationship with each other. I also want to acknowledge the McKercher Law Firm for being the sponsor of the lecture series. Their support allows events like this to happen that reach beyond the classroom into the community, into the legal community and into the public community, to have informative and engaging conversations that are relevant to all of us. We have room 30, which is on downstairs and close by, set aside as a spillover room because we anticipated that this would be a sellout crowd. And I think so far we're able to fit here, but we do have that room available with a live stream into the room. So that's an option. We also have public Wi-Fi. Most of you sitting here already have student access to the Wi-Fi. But if you need public Wi-Fi, I suggest you go to the U of S public avenue. You're going to be invited to engage with that through the presentation today. If you don't have access to that, that's okay, because our speaker will also share with you on the big screen what's happening live that way. So with all of that, by way of logistics and housekeeping, I want to introduce our speaker, Shannon Salter. Shannon is the chair of the Civil Resolution Tribunal in BC, which is a very exciting development, and you'll hear all about that. But she also brings a lot to her experience in her discussion today. She's an adjunct professor at UBC. She has her law degree and her LLM from the University of Toronto. She's practiced litigation at a big firm in Vancouver. She has experience with quite a number of administrative tribunals. And she's also the co-author of the BC Administrative Decision Makers Manual. That's part of what's on her CV. How I know her is as a dynamic and creative, I think, change maker in the justice system. At the forward edge of how third-party processes can assist people to deal with conflicts that we might think of as legal conflicts and legal problems. I'm not going to say a lot about that because Shannon can say that in a way that's much more exciting than I can. So with all of that, I want to introduce Shannon and thank her for joining us here today.
Thank you, Michaela. Thank you so much, Michaela, and thank you to all of you for joining me today and giving me the opportunity to talk about my favorite subject. I get teased a lot for my enthusiasm for the CRT, and I think a couple of you have had to hear me talk about this a couple of times. I'm sorry, this makes 3. But my elder daughter, who's 6, likes to say, tribunal, tribunal, tribunal. That's all you talk about is the tribunal. So you're doing her a favor as well, because she doesn't have to hear me go on about it, at least today. So welcome to all of you. I understand you've had a very exciting program so far, a morning of a negotiation. And I'm excited to tell you about this new project that's really one of a kind in Canada. So get your smartphones or your tablets or your laptops handy. Or if you're just mentally exhausted from all of your negotiating, you can sit back and relax as well. But this might seem a bit more real if you go through it with me as well. So what I'm going to do is give you a bit of a 5-minute overview of the CRT, and then we'll use a fictional but pretty similar to real-life case study to actually explore the CRT technology. It's usually the reverse of what I normally do. So I'm throwing you in the deep end, And at the end, I'll give you a bit of a discussion about why this thing came about, why it is that we're doing something as crazy as the CRT in British Columbia. And there'll be lots of time to hear from you as well. And I'm really interested to hear what you think. So, what is the Civil Resolution Tribunal? Well, it is, like any other administrative tribunal, part of the justice system. It fits in, as the Supreme Court of Canada says, somewhere in the void between the executive branch and the judicial branches of government. But it is part of the justice system. And in this sense, it's to be distinguished from software programs, IT programs, or other projects that you might see from nonprofit organizations or for-profit organizations. And there is a whole cottage industry of these that are aimed at dispute resolution. That's a whole topic for another day. But the CRT is the only project in Canada using ODR as part of the justice system. So it's the only online tribunal in Canada. And in fact, it's really one of the only ones we know of in the world. There's a new project out of Utah that is similar, but isn't implemented yet. And as a result, we've had some really distinguished international visitors. So Lord Justice Briggs from the United States, that's my really bad English accent, came to visit us in British Columbia in May because the UK government is considering starting Her Majesty's Online Court. That's actually what they plan to call it, Her Majesty's Online Court. And the judiciary there is really driving that forward, and they've identified the CRT as the model in the world to watch for how to do that. So that's flattering, also very nerve-wracking for us. Lastly, we get a lot of attention for being an online tribunal. But really, I'm not a huge technology nerd. I'm a nerd for a whole pile of other reasons, but not a huge technology nerd. I don't worship at my computer. I think that technology is a really useful tool, but it's a useful tool because it enables us to do something that I think is much more transformative. And that's to use this blank slate we have with the CRT to really build the justice system around the public, to bring it to them, to build it around the context in which they operate, the fact that people have jobs and families and they live in a particular place and time with sets of characteristics that might make it easier or harder for them to access the justice system. So technology enables us to go to where people are, build a justice system around them, and I think that's one of the things that makes it exciting. So what does the CRT do? Well, by virtue of the Civil Resolution Tribunal Act that was passed in 2012 in BC and then amended again in 2015, we have two main buckets of jurisdiction. And I'm not going to bore you with the intricacies of condominium law in BC, although I will in a moment in your active exploration of this to some degree. But our two main buckets of jurisdiction involve condominium disputes. That's something we call strata disputes in BC, and you'll see that term when you're using the technology in a moment. And also small claims disputes. So small claims are very familiar to all of you probably. Your everyday kinds of low-value disputes that span all kinds of areas of the common law and have in common just a common monetary threshold. In BC, that's $25,000. Half our population, though, lives in condominiums in BC. And even in rural parts of the province, there's a high percentage of condominium property everywhere you go. And until July 13th, you had to go to our Superior Court to resolve any of these kinds of issues. Any of your bread and butter, low-level neighbor disputes, you had to go to the Superior Court for. And our strata lawyers, some of whom serve as adjudicators now on our tribunal, tell us that for their clients to take your average neighbor dispute to the BC Supreme Court on a one-day petition costs between $25,000 and $35,000. So as a result, these kinds of disputes were just not going anywhere. They were just kind of festering in these little communities. Now, under the CRT Act, those kinds of disputes have to come to the CRT instead. So a quick snapshot of how this thing works before we get into actually using a test case. The CRT has 4 distinct phases. The first phase is a free legal education information tool called the Solution Explorer, and that's what you're going to be using in a couple of minutes. I know I keep saying that, but I promise it's true. That is free for the public. It's anonymous. You don't need to have a CRT claim to use it. And the goal of that is to give people the kinds of information that they need to make sensible decisions about their next steps in their process. It used to be that if you had a legal problem, you would go and see a lawyer, and the lawyer ideally would say, yes, you've got a strong case, or no, you don't have a strong case, or here are some of the risks of going to court and pursuing this, or here are some of the benefits, here's how long it might take. But overwhelmingly, at least in BC, people aren't doing that for civil claims anymore. They're often representing themselves. And the first time that they learn about how strong their case is sometimes, if they're in the very small minority that actually go to trial, if they're on the losing end of a judgment, or more likely, along the way, as they get discovery of documents and are forced to learn more about their case, they may learn then. But by then, they may be many months and many thousands of dollars into the process. We're trying to give people that information for free up front so that they can make well-informed decisions about their next steps. The next stage is negotiation. So that's what you were doing this morning. It's at this point that somebody starts a CRT claim, fills out their intake form, and has the chance to negotiate directly with the other side. This does not resolve very many disputes in our process, because if people were successful at negotiating, that's usually something that they've done earlier, before they even come to us. At this point, they need help. But it is a bit of an off-ramp for people who might just need to work out a payment plan, for example. The heart of our process, though, is in the third green box, and that's the mediation phase. So it's at this point that one of our trained facilitators works with the parties through whatever communication method works best for them and helps them reach a consensual agreement. And we anticipate that this will resolve between 70 and 80% of the disputes in our process. Last but not least, we have adjudication. Adjudication is there as a last resort, though. So really what we're doing is flipping the traditional justice model. The traditional justice model is that you start a claim and every step you take is meant to prepare you for a day in court. The trouble with that is that only 2% of cases where somebody bothers to take their forms down to the registry and file them actually gets to trial. And those other 90% of the cases don't get to trial. But every step that you take is meant to prepare you for a trial that overwhelmingly is unlikely to come. So instead, what we've done is tried to flip that model, front-load early dispute resolution, front-load information and resources so that people can get through the process quickly, ideally reaching a consensual agreement. So mediation is the heart of what we do. And I understand that that's what you guys have next on your agenda this afternoon. So the Solution Explorer is that first stage. It's a guided pathway system. How many of you have heard of guided pathway or expert systems before? None. Okay, good. Hopefully I won't be boring you then. It's really a new way to deliver legal information to people. So when the internet was first being used to give free legal information to the public, typically the form that would take is, well, here's 10 or 15 pages on contract law. Here's 20 pages on condominium law. But somebody who has, for example, a condominium problem doesn't want to be a condominium expert. They want to know if they can keep their chihuahua in their rental unit. And that's a very specific question. And you can give people specific information geared at answering that question if you ask them questions first. So really, it's a form of basic artificial intelligence that helps you narrow in on the person's actual problem, giving them bite-sized bits of plain language legal information along the way, and then ideally tools to help them resolve the problem. So that's what a guided pathway system is. So typically you ask some questions, you zero in on the problem, and then you give people tools. So that's what we're going to do right now. So I'm going to show you a brief video. It's about 2 minutes long, 2.5 minutes long, and it's about Sonia. And Sonia has a strata problem. Stratas are condominiums in our part of the world. And this is not actually a real case study, but it's really typical of the kinds of cases that we see now that we've been open, and the kinds of emails that we get every day.
Please meet Sonia. Sonia is 71 years old. She considers herself to be mostly retired, but she does work 1 day a week at a local arts and crafts store to help make a little extra money. Sonia owns a condominium in Chilliwack. For the last 8 years since her husband died, Sonia has lived there alone. But she's been in a relationship for a couple of years now with Walter. They've decided to live together in Walter's condominium. It's a little newer than Sonia's. Sonia doesn't want to sell her condo. She wants to let her adult son Mark, who just returned from university, move in. He'll pay her $900 a month in rent to help cover Sonia's costs. Sonia's a little bit scared of her strata council and didn't want to get into trouble with them over her rental, so she knocked on the president's door and told him about her plans to rent her unit. To Sonia's surprise, the president said no right away. He told Sonia that the strata bylaws have a restriction that only allows for 5 rentals at any one time. He also told Sonia that 5 units are already being rented. Sonia is upset. She doesn't want to sell her condo, but she can't afford to keep it empty, and it would be a great place for her son to live. She called a lawyer to ask if they could help. The lawyer said Sonia would have to pay a retainer before he looked into it. He also told her that if she has to go to court, it might be expensive, and she might not even win her case. If she lost, she might be ordered to pay the strata council's legal costs. Either way, he said it could take a while to work things out. So Sonia asked the lawyer what else she could do. The lawyer told her she could bring a case to court on her own, but it's complicated. She would have to research the law, decide what type of case to bring, and what to argue. She would also have to figure out the court's process. She went to some websites describing the court rules and immediately decided it would be too complicated for her to handle on her own. Sonia is upset and confused. She's talked to 2 people already, the strata council president and the lawyer. They both seem to know more than her, and they both made her situation seem pretty bad. Sonia's feeling powerless. She doesn't know what to do about her situation. Here's where you come in. Use the Solution Explorer to help Sonia learn about her options.
So that's what we're going to do. So now's the time to take out your device and your smartphone, and we're going to pretend that we are Sonia. Or maybe we're not Sonia, but maybe we're Mark or Walter, and we're helping Sonia as well. So now is the time to go to the CRT website. So it's civil resolution.
Have you ever had a problem or a conflict and didn't know what to do about it? Maybe you've been involved in a legal dispute and just wanted a little bit of guidance about your...
We have a lot of CRT videos if you'd like to watch more. You can subscribe to our YouTube channel, but we won't do that now. I won't torment you with all of our YouTube videos. Okay, so you want to go to civilresolutionbc.ca or just Google Civil Resolution Tribunal and it should take you there. So I'll give you a couple of seconds to do that. While you're there, you'll see that we have an implementation blog. So we have a lot of communication with the public. We do a ton of user testing, and I'll tell you a bit more about that later. But right now, I'm just buying you time to get to the website. Okay, so everybody is now hopefully at civilresolutionbc.ca. And this is where you have to go now to resolve your strata property dispute. And it's primarily online. That's our default. So to get to the Solution Explorer, you just click the Getting Started button. And we give you some basic information about things like limitation periods and where to find condominium documents. We also have another video. I told you we really like videos. There's another video there if you are interested. But here is where you use the Solution Explorer. So one of the things that we learned through a lot of user testing is that people don't like having a lot of preliminary information, that Sonia in this situation is likely feeling a bit stressed out, a little anxious, a little worried. She doesn't really want to read about limitation periods. She doesn't want to find out about where to get her condominium documents. She wants help for her problem now. And that's what we learned through user testing. So we've tried to put that information behind links. We used to have a lot of pages actually in the Solution Explorer, but we learned that that doesn't really meet public needs very well. So so there's solutions for strata councils. Those are the condo boards. There's also solutions for strata owners, tenants, and occupants. So this is where Sonia would go. And initially, she would see a user agreement. This is still a quasi-government body, so you can't really get away from having no disclaimers or legalese. But it is shorter than the iTunes user agreement, so there's that. And I have actually read it, so I'll click yes. And now we're just trying to get us to the initial page. So here's where I'll let you take the driver's seat. Are we using a public or private computer? Well, I'm using a public one, but you're all using private ones, I think. So we'll click that. The only difference between the two is that if you're using a public computer, and we know that a lot of people who are particularly low income use computers in public libraries or other public spaces, The only thing they won't be able to do is download documents to the desktop, and there'll be a quicker timeout so that their privacy is protected. All right, so now we're getting to the first question that's actually useful and pertains to Sonia. So this comes from thousands of hours of sitting down with condominium experts and asking them what the most common problems are that people see in this area. But this could be applied to anything. And in fact, if you're interested, you can go onto the website and see the Solution Explorer for small claims issues. It's also being used for residential tenancy issues. So you can use it for any time that you're trying to give complex information to the public in a digestible, plain language way. So condominium law is very complicated in BC. The Act has 322 sections, an average of 2 subsections per section, plus regulations, plus the standard bylaws. So very complicated, plus a bunch of other documents. So roughly 900 provisions, never mind the regulation. We're trying to get people to relevant information within 2 to 3 questions in about 5 minutes. But it's not an easy thing to do. Okay, so what can we help you explore? Which category do you think of question does Sonia's problem fit into? Yeah, exactly. But what would happen is if you couldn't find a category here at all that fit your problem, what people can do, or what Sonia could do, is just send us an email. And we get these all the time. And that gives us a couple of opportunities. One, it's an opportunity to get back in touch with that person and point them in the right direction if they've missed something. But it also tells us that we haven't laid this out as intuitively as possible, or maybe there's information we need to include that we haven't yet. So it drives our content development for the Solution Explorer. Okay, so Sonia Estrada won't give her permission for something. But if she was very confused about this as well, she could also just ask us a question. People can ask us questions here, and eventually this will be populated with Q&As as well. If she's finding that the technology is glitchy, she can report that as well. And we've also given her an access code. So this access code lets her stop. For instance, maybe she needs to make dinner or play with her grandkids. I don't think Mark has kids yet, so that's a bad example. But she can come back when she wants to on her own schedule. Because this doesn't store any personal information, she needs an access code to do that. Okay, so in our case, our issue is here, at least at this point. The Strata won't give me permission for something. Well, what won't the Strata give you permission for? This should be a pretty easy example to figure out. What's the next button she would click? Renting my Strata lot, exactly. And again, if the issue is more complex than one of these things, then she can tell us what's missing. But it is actually quite surprising. You can boil down about 90% of problems in this area to these 5 options. And it shows you that things can be made much more simple for the public, I think. Okay, so we have some basic information from Sonia right now. And now we have enough information to give her a targeted piece of plain language legal information. So this is about a 1 and a bit page document. And it was written by our Strata experts, and then plain language by plain language experts. So what we learned the hard way is it's really not a great idea for lawyers like me to be trying to plain language things. And this was a humbling experience. I've tried to plain language things, and I'm getting better at it every day, but I'm not good at it yet. So what lawyers think of as plain language and what plain language experts think of as plain language are 2 totally different things. But you have to write at a grade 6 level, it turns out, to create public information that's easily digestible to most people. And it doesn't matter if you're providing health information or legal information or information about taxes. It has to be at a roughly grade 6 level. So that's what we've tried to do. Okay, so we have some basic information about rentals. And what this says is that even if you have a bylaw that says you have rental restrictions, there are some exceptions. And one of the exceptions is if you want to rent to a family member. And it talks about what you can do and what the deadlines are as well. So one of the ways that the other ways that we collect public feedback here is through the star rating system. So people can really quickly tell us what they think of this resource. They can also hit this very cathartic not helpful button. And that's a big way to let us know this really sucks. So we have weekly meetings with our whole team to go over public feedback. That includes the emails, that includes the star ratings, that includes the big red button. And if this is getting, for instance, if this resource is getting a lot of negative feedback, we know right away we got to do something. We got to look at it, we have to change it, and we don't have to wait for a 2-year study on our program or a massive core review. We just do it right away. We have change meetings every single week. So people can print, download, or email this resource to them as well, and it can also keep on going, and they can come back. Another thing our user testing showed us is that, this is shocking, a bunch of lawyers and IT professionals, like the group of our team that developed this technology, turns out they don't think like the everyday member of the public. Shocking, I know. But lawyers and IT professionals in common tend to have this pattern of thinking that's very linear. If A, then B. Well, if you have problem B, then C. It turns out that if you have a problem, what the public told us is that they just want to zoom in, and they'll ignore a bunch of stuff along the way, and then they want to be able to bounce back and forth. And we used to make it really hard for people to do that. We'd have little, very paternalistic warning signs that came up and said, well, are you sure you want to change your exploration? Do you really know what's good for you? And we got rid of all of that based on user testing. And instead what we've done is made it very easy for people to jump around. So as they see resources like that little PDF, they stack up on the left-hand side so that people can go back when they need it. Okay, so we've given her a bit of bite-sized legal information. Now we're asking her, Sonia, does your rental fit into any of these 4 rental categories? So what do you think? It's another good reason why it's good to have it on your screen or look at a neighbor's screen, because the print is a little small here. Yes? Which category does it fit into? Pardon me? Number 3. So number 3 is you're renting to a family member. So Sonia could click yes. And this is a bit of a duplication, and we need to actually streamline this a bit, but we're asking which category again, so family exemption. Well, like most things under the Act, family is a defined term under the Act. So family doesn't mean everything or everybody. So now we're able to give Sonia a bit of bite-sized information about what family means under the Act. So for example, a family member under the Act means an owner's parents, children, or spouse. Doesn't mean your cousin or your grandparents. So again, a very short little bit of information here, and again, asking for feedback as well. Okay, so then we've given her the information she needs to make that determination. So she wants to rent to her son, Mark. Mark is a child of hers, so would qualify. And now we're pivoting a bit and saying, we've given you the information we can give you. Now what would you like to do with that information? And here's where we start turning into giving people tools to be able to resolve their own dispute without ideally ever even coming to the CRT at all. So one of the things she can do is write a letter to her strata corporation. She could also have a hearing with the strata council. Or she could decide that, well, it turns out she actually doesn't qualify. Maybe she did want to rent to a great-grandchild or a grandchild, and that wouldn't count, and so she'd comply with the strata's decision. So what do you think Sonia should do in this case? Pardon me? Write a letter. Yep, she could write a letter. Or she could also have a hearing with the strata council, and I don't mind. We can go down either road. The benefit of having the hearing is that it's a prerequisite to going to the CRT, and the strata has to hold a hearing in 4 weeks. But we can go the letter route as well. So that was the first thing I heard. So we'll go the letter route. And so we've got a little bit of what's called X text underneath, explanatory text, explaining what this means and what you'd like to do. Okay. So we're going to write a letter. And like everything else in condominium land, there are specific ways under the Act that you have to do this. For example, sliding a letter under the condominium presence door doesn't count. You have to deliver it in particular ways and send it to the right people. So we give people information about that. So now we're getting to what is the most popular tool in the Solution Explorer. This is a template letter, and it's everywhere in the Solution Explorer, and it changes depending on people's answers. It's already pre-written, so it has template language citing the relevant parts of the Act or what people are actually asking for. How many of you volunteer for pro bono clinics through your one program or another? So most of you. How many of you have had the experience of having a client come in and it either hasn't occurred to them that they should write a letter before taking a formal legal step, or if it did, they feel completely underqualified to write that letter. They feel that they don't have the language, they don't They aren't a lawyer themselves. They don't know the right parts of the Act. Has that experience happened to any of you? A few of you. Not very many, but I can tell you it's a common thing, and we see it every day. So it either won't occur to people to negotiate, or they won't feel qualified to be able to write that letter themselves. So this template letter is very, very popular with people. And so people, all Sonia would have to do is just enter her information, and she can tab through all of these fields. Then she has a chance to edit the letter herself. And for somebody who's at a public library and doesn't have a computer, you don't need any software for this. This is an in-text editor. So if she doesn't like our language, she can rewrite it. She can also edit it however she'd like. And then she has to send it to herself because we don't save any personal information. So she can email herself a copy, download it, or print it. And we warn people about that because we don't want them to lose their letter. Okay, so now Sonia has to deliver her letter. Again, there's specific ways that you have to do that. Some ways don't actually count as giving notice to the strata of anything. And at this point, we've reached the end of her exploration. So all of the resources that we've given her are here. There's a breadcrumb trail of all the answers you guys have provided. And we're taking her now to a summary page. So she can print this out or email it to herself, but there's just a natural language summary of her problem and what we've told her, as well as all the resources, again, that we've shown her, and some external resources, like links to the Act and that kind of thing. So at this point, Sonia could send that letter, hopefully resolve the dispute with her strata herself, or she could start a CRT claim, and that happens seamlessly from the Solution Explorer. The benefit of that is that people don't have to go and find a paper application form, but also we already take her to the right application form. We know that she's a strata owner or tenant, so we don't show her the forms for other kinds of users. We also have some information about what her issue is, and it's right here. So at this point, she would go on and fill out the application form. And I'm not going to torment you by making you watch me do data entry on forms, because that's just terrible for both of us. But I will show you some snapshots of how we developed the form, because I think actually this process is really important in terms of access to justice. The last thing I wanted to mention about the Solution Explorer and about all our technology is that it operates on something called responsive design. Has anyone heard of responsive design before? Okay, it's just basically the concept that your technology should look as good on a mobile phone or a tablet as it does on a desktop. So you've probably been to some websites, government websites, that look horrible on your phone, right? It's like 2-point font and you have to really scroll. That's a huge barrier for people. And the low-income advocates that we talk to say that any technology that's meant to increase access to justice has to work first and foremost on a smartphone, because that is the technology that someone who has a low income is most likely to have. They're less likely to have a desktop, less likely to have a laptop. They will almost certainly have a smartphone, though. So you don't have to download any app. You just go to the website, and it looks good on a mobile device. Couple of little things I wanted to say about our application form. So Sonia's gone ahead now. She can't resolve her dispute with her strata corporation. She has to start a CRT claim. The way we designed our form, and I'm not aware of any other tribunal or court that's done this, is through co-designing it with the public. So we started with community advocates. We walked through all of our designs for our form with them. We had feedback from them about whether their clients could use the form, made a ton of changes. Then we actually recruited members of the public who had had a past dispute. We gave them a gift card to fill out our form, and then we interviewed them about that. And that doesn't sound like much. It's just a form. But it turns out that half of all adult Canadians with a post-secondary education, so basically you guys, about half of you guys wouldn't be able to fill out a reasonably straightforward form. I fall into that category. And some of you will have the experience of having things bounced by the registry when you're practicing, and so you'll maybe think of this statistic. But you can imagine it's really challenging for people who don't have that level of education or who don't speak English as a first language to fill out government forms or even court forms. And so designing them at a grade 6 level in a really simple way is actually a huge boost to accessing justice. So the quick things I wanted to point out are a couple of ways that we try and accommodate people with special needs in the system. One is that we ask people if there is a way we can accommodate them better. So we ask people if they have difficulty reading or writing in English. We ask them if they have a visual or hearing impairment or a mental health issue. This is all optional, and it doesn't go to the other parties, But what happens is that if one of our intake workers is screening a file and somebody indicates that they have a hearing or visual impairment, and maybe they've filled this out with the help of a friend or family member, what our staff will do is, for instance, call somebody who's indicated they have a visual impairment. We'll call them and we'll ask them, what can we do to make it easier for you to navigate this process? What supports do you have in place? Would you prefer that we primarily had telephone conference calls instead of communicating in writing? So it's not the case that we can always do something, but we think it's worth asking. And so far that's been obviously very popular, particularly with community advocates. We also get asked a couple of questions in our intake form that are really meant to facilitate the mediation phase. So these are questions that will seem familiar to you now, having gone through part of this week already, but we ask people, what have you done to try and resolve this so far yourself? And that lets our mediators take the temperature of the dispute a little bit, so that they're not suggesting or guiding the parties in a way that really duplicates the efforts they've already made. And we also ask why resolving the claim is important to them. This isn't legally significant, but it's helpful at identifying what the interests are underlying the dispute. Okay, so that's the intake process. At this point, the parties have a brief opportunity to negotiate themselves. We don't have much to do with this aside from putting them to get in touch with each other. It's really, as I said, a low-cost, low-intervention off-ramp to the process. Most of the work is done in this facilitation phase. So about half of our caseload is currently in facilitation. We have a team of dispute resolution experts. They're not all lawyers, but they are dispute resolution experts who work with the parties through whatever means is best for them. So that might be telephone for some people, that might be email for other people, it could be video conferencing, it could be text, it could be mail. It's very, very flexible, and it's asynchronous, and it's very much like a med-arb model in many ways. I don't know if that's something that you've covered already, or you will later. But it's meant to, part of the reason that we call these people facilitators instead of mediators is, at least in BC, mediation has a very specific term. It means sometimes a very specific thing. This is a very flexible approach to dispute resolution. So what happens after the magic of facilitation? Well, if there's an agreement on how to resolve an issue, that can go to a tribunal member like me, and I can make a consent resolution order. That consent resolution order is binding, is a binding tribunal order. It's also an enforceable court order. So people get the certainty of having a mediation agreement that's turned into a binding court order. What would happen if you had a private mediation and the parties came up with an agreement themselves? What would happen? What would you have to do if one of the parties broke that agreement? Anyone know? Exactly. Yeah, exactly. So how is it better then to have a court order at the end of your mediation? Yeah, you're not having to determine whether you had a contract, did you have offer and acceptance, did you have consideration, did you have was there a breach, all of these things. Instead, you have a court order, right? And if somebody breaches a court order, they can be held in contempt. So theoretically, anyway, enforcement is easier. Okay, so that's what happens if there's an agreement. If there's no agreement, then the role of the facilitator is to help guide the parties through the hearing process, help make them understand what a hearing is, what they need to do to prepare for it, how to gather evidence, what is evidence, how to assemble their submissions. And we do that in a very paint-by-numbers way because this is confusing to people. How do you prepare for a hearing? So in a neutral way, they help prepare the parties for adjudication. The adjudication piece is really the last, hopefully rarely used step. And again, this is a way that we reverse the traditional justice model. Typically, mediation processes, even if you have mandatory mediation, tend to be a detour on the way to your court day. That's the way the parties sometimes see it. That's also sometimes the way lawyers see it. Oh, we have to do mandatory mediation. Oh, we need to stop and go through this mediation process. They view it as a detour or an add-on. It is not the heart of our civil justice system. What we're trying to do with the CRT is make that early consensual dispute resolution the heart of the process. Adjudication is there if that doesn't work out for you, but it's meant to be there as a last resort, and it's meant to support the facilitation phase. The adjudicators make orders. If somebody is not participating fully in facilitation, if they're not obeying the facilitator's directions, and under the Act, the facilitators can make a variety of directions, the tribunal member will make an order requiring the parties to comply with the facilitator's directions. So in that sense, the adjudication process is there to support the facilitative process. Our hearings are mostly through written hearings unless admin law principles require you to have an oral hearing. And in that case, it's telephone or video conferencing. And our reasons are written in, hopefully, increasingly plain language writing. So we have 16 tribunal members across the province, a lot of very senior lawyers, a lot of QCs, and they all had to do a boot camp for about 4 days on how to stop writing like a lawyer. And that was a lot of unlearning. So we're all trained by virtue of our education to write using as many big words as possible, because we're also trained that that shows how educated and intelligent we are, and is really difficult actually to put all that aside and write at a grade 6 level and to convey complex concepts really in a plain language way. So they had to go through a boot camp to do that, and the goal is grade 6 level writing, very short decisions, written decisions, and they are published as well. There are appeal methods. I'm not going to go over this in too much detail. I don't imagine anyone's all that interested, except to say that the CRT is not the last word, and there are appeal methods to court, and of course there's always judicial review available as well. So, at the end of all of this, why? Why bother with this technology development? Why put so much effort into user testing? Why not just roll condominium disputes into the existing small claims court and call it done? Well, the idea was that this is a way to experiment in different ways to address the access to justice crisis. There is no legal aid for condominium disputes or small claims disputes in BC. Is there any legal aid for small claims or condominium disputes in Saskatchewan? I would be shocked if there was. No? Not likely to be, right? If there's a choice between another MRI machine or another special education teacher and a free government lawyer for your small claims dispute, I can't see the small claims dispute winning that policy choice very often. At the same time, though, you have, like Saskatchewan in British Columbia, a huge rural area with very limited access to legal services or courthouses, and increasingly complex kinds of disputes, as well as a lot of delay in our existing court system and a high degree of cost. So if you're in rural British Columbia, you often have to stay in a hotel room and travel hundreds of kilometers to get to a courthouse. And never mind taking time off work and arranging childcare. It's an expensive proposition. And at the end of the day, because of all of this, it's not surprising that so few cases actually get to court. And at the end of the day, what you also have is really a lack of proportionality. So proportionality is this concept in the justice system that's gaining a lot of traction, but it's a complex idea, because when it comes down to it, what does that actually mean? It has to mean something. The low-value claims maybe don't need a whole courtroom and a judge being paid $250,000 a year, and a registrar, and a court clerk, and a sheriff, and a sanitation staff as well. Maybe a $500 claim over hardwood floors doesn't need all of that. What does proportionality really mean? So these are the things that we're trying to address. We've seized the opportunity provided by this legislation to really build this in cooperation with the public. I like to say that we've co-designed it with the public. And to do that, you have to really understand what the public needs and wants. So we've done all kinds of things, including surveying, and what we found is that overwhelmingly people in BC are online. So it makes sense to provide them with justice services online. And interestingly, and this is only interesting to groups of young people like you, because I found that in groups of older people, they just get offended by the statistic, but it turns out that 69% of people in BC over the age of 74 are also online every day. So I stopped saying that at community gatherings on a Wednesday night at a library, because they all look at me like I'm very crazy and insulting. They all know they're online. And it's just a question I get from younger people who say, older people will never be able to do this. And we have to distinguish too between asking people to do coding and asking them to Google something or click a radio button or enter their email address. So we're asking people to do things that they already do. 80% of people in BC do online banking. 77% of people look online for government services. We're really comfortable with texting and emailing. So if you don't ask people to do anything more complicated than that, then you're operating within their comfort zone. Really quickly on this, because I'm mindful of the time, Overwhelmingly, what people told us, too, is that they want to be active participants in the resolution of their problems. They don't want a judge or a tribunal member like me telling them how it's going to be. They want to have a say. And so everything you're learning this week is really consistent with what the public seems to value. They value being able to help determine the outcome of their case. And I'm sure you have heard these statistics or will, but people tend to be much more satisfied, not surprisingly, with outcomes they've had a hand in. And 81% of people told us that they would use something like the CRT, which was a good vote of confidence, seeing as this didn't exist at this time. This was 2015. So we have a lot of, we've done a ton of consultation. I've probably spoken to 7,000 or 8,000 people in the last couple of years. We've built strong relationships with community advocates, and we've developed some key guiding principles that drive everything we do. We focus on early dispute resolution because we know from research from the Canadian Forum on Civil and Family Justice that the longer somebody has a civil justice problem, the more their mental, physical, and financial health suffers. So a shocking number of people can actually attribute, rightly or wrongly, an ailment they have to their civil justice problem. So if you can get people through the process quickly, ideally with an early resolution, that's better for their health. We focus on flexibility, giving people choice about how to resolve their dispute, but also trying to make sure we're not getting too cocky either about how we think things should be done. So we strive for continuous improvement and maintaining flexibility, and we do that, as I keep going on about, through user testing, because the public won't hesitate to tell us if we've got it wrong, and that keeps all of our egos, I think, in check, which is really helpful. It's accessible. You've seen how it works. The cost is roughly what the small claims court costs, but in partnership with low-income advocates, we've designed a very generous fee waiver program as well, so low-income people don't pay fees at all. And then last but not least, focused on efficiency, on proportionality, on avoiding duplication, that boring process stuff that really drags people down if you don't do it properly. So obviously a key value is continuous improvement, and that's what our change meetings are about. We're doing user testing even though we've implemented most of the tribunal, and we keep doing this over and over again. So if you want to see that cycle, look on our website. You'll see a call for testers, and then you'll see the testing, and then we'll report back. What did you tell us? What are we doing about what you told us? And we just do that over and over and over again. So as a result of this, this is a snapshot of some recent beta testing we did right before we opened, and it's about the 6th or 7th round of this. And the reason I show this slide is because I think it demonstrates that repeated user testing really saws off the rough edges. Typically, the way that government or court technology is developed is that an institution will identify a problem, like, okay, well, people seem to be having problems with X. And then they'll say, don't worry, we'll fix it. And then they go away for 2 years, develop software, bespoke technology. It turns into a giant Frankenstein because everybody has their 2 cents or their pet feature, like that access code or those little pop-up buttons that I was talking about. And then they say, ta-da, here you go, isn't it great? And the public says, no, it's terrible, it doesn't work. And I haven't visited a jurisdiction that doesn't have at least one example of a giant technology project that's gone wrong. The way to counteract that is just doing incremental user testing. You build a little bit, you test it. You build a little bit more, you test it. And the result of that is pretty high degrees of satisfaction with the way that it works. But it does require taking risks because it can be embarrassing to go out with technology that isn't great. But you have to take that risk, and you need to adopt the software mantra of failing fast and often. So we're headed towards accepting small claims in the next couple of months, and we expect that this technology will be rolled out to other tribunals in the future as well. So with that, I think there's time for questions, Michaela?